I think we'll start now. Could the barristers pay attention, please? Well, thank you everybody for coming. We want to talk about the Companies Act 2006, which is the longest ever act. It's 1,300 sections, split into 47 parts plus 16 schedules, and it got the royal assent on November 2006. It makes fascinating reading. We hope that we're going to be able to give you a bit of a digest to make some sort of sense of it with my colleagues Alex Hall, Ian Mitchell and Rob Thacker. Alex Hall. We'll talk about directors' duties.
As Lynn said, I'm going to be talking about directors' duties under the Companies Act 2006. Really going to consider what are the actual duties, how should they be applied, and what you should have been doing since the 1st of October 2007. So what should you have been doing since 1st of October? Well, we suggest that you should have been making clear to all of the directors what their obligations are, what their duties are, and putting in place a training system for them. Very important is to make sure that there are minutes of all decisions, especially taking into account section 172, so that if an audit is required later, that can be dealt with.
The first issue I'd like to deal with is corporate responsibility. There's a lot of discussion about what is corporate responsibility, and of course it's introduced under the director's duties, and 172D talks about the impact of the company's operations on the community and the environment.
As we've heard, the Act brings all sorts of wonderful new ways and means into company law, and that's fine for new companies that are born under the new regime and grow up under it. But where does that leave all the poor myriad of companies that are existing now and grew up under quite a different regime? And what should they do? And the answer is, it's really sort of procedural matters. I do think they need to look quite a lot at how they run their operations and how they regulate themselves, because an awful lot of the matrix that they have grown up and have been designed to fit has changed. And in a number of aspects that I've listed, I do think they need to review what their present articles say and consider if those should still say the same or should be changed.
I'm just going to run through who's at risk, who can sue you if you're a director or an officer, why you should buy it, or certainly think about buying it, how the insurance market has generally reacted to the new Act, risk management, which picks up on a lot of points we've already discussed here, and then just some information, really some helpful tips on things you think about when you are buying insurance. Certainly smaller businesses are exposed because they don't necessarily have the resources to put into understanding the new Act and taking on board the new implications for them as directors. They've got less infrastructure, etc., to be able to manage these changes. And secondly, with smaller companies, and also companies where the director's name is on the label, on the trading as, when their name is so upfront, as individuals, they're certainly much more in the limelight, and employees, as well as the numerous other people who could sue directors, know who they are, and therefore they are more exposed than the business generally. So that's why I say that these covers need to be tailored to the needs of your business. And with that, I think we're over the question and answer session.
Thanks, Rob.